The question of whether unrepresented parties should be able to appear in courts and tribunals is a complex issue that demands a nuanced examination of the Canadian legal system. Canada has historically recognized the rights to self-representation rooted in the fundamental principles of ensuring access to justice. As Section 7 of the Canadian Charter of Rights and Freedom, while not explicitly mentioning the right to self-representation, has been interpreted to include the right to a fair trial, encompassing the option to present one's own case. Individuals who represent themselves in legal proceedings come from various income and education backgrounds, and the reasons for not seeking legal representation are diverse. Studies reveal that the motivation behind individuals opting not to hire a lawyer or a paralegal can be intricate and varied. The predominant motivation is the perception that they cannot afford legal representation or do not qualify for assistance. However, the motivations behind litigants choosing to represent themselves can be intricate, which include the growing trend of a do-it-yourself approach and a belief among some self-represented litigants that hiring a lawyer may not substantially improve their outcomes or affect their case. Other reasons include difficulties in finding a suitable lawyer, dissatisfaction with past experiences, and in some cases, a lack of trust. Overall, these parties commonly describe that their experience is anxiety-inducing and uncertain. Handling unrepresented litigants presents unique challenges for legal representatives, highlighting the need for a delicate balance between effectiveness and ethical considerations is crucial. The illustrative case of Kent v. Waldock serves as a stark reminder of the importance of maintaining exemplary behavior with the court, emphasizing the impropriety of mistreating unrepresented litigants. Such actions are a clear violation of paralegal rules of conduct and the Paralegal Professional Conduct Guidelines, which mandate that a paralegal must exhibit courtesy, civility, and good faith in all their professional interactions. These rules and guidelines outline that it is a paralegal's duty to provide legal services and fulfill responsibilities to clients, tribunals, the public, and fellow members of legal profession with honor and integrity. As stated in Paralegal Rules of Conduct, Rule 4.05 and Paralegal Professional Conduct Guideline 9 and 12, paralegal bear a distinct responsibility when representing a client in a matter where the opposing party lacks legal representation. The concern lies in the possibility that the unrepresented individual may perceive the paralegal as safeguarding their interests. In dealing with an unrepresented party, the paralegal must take two essential steps. First, ensure that the unrepresented party is not under the impression that the interests are being protected by their paralegal. And secondly, explicitly communicating to the unrepresented person that the paralegal exclusively acts in the interests of their client, and any comments made may be biased against the unrepresented person or in favor of the client. Additionally, judges find themselves in a challenging position balancing their obligation to ensure a fair hearing, which may involve assisting self-represented litigants with the need to maintain both actual and perceived impartiality. This dual duty requires judges to appear fair to both represented and unrepresented parties. Numerous significant and innovative efforts are underway within the Canadian justice system to assist individuals representing themselves in legal matters. These initiatives, often collaborative, involve various stakeholders, including government body, the judiciary, and the legal profession. Government involvement primarily focuses on supporting research initiatives and pilot projects, with jurisdictions conducting comprehensive evaluations of the civil justice system's overall functioning. For example, court services in the Nova Scotia Department of Justice recently conducted a study to assess the needs of self represented litigants. The judiciary is also actively addressing challenges posed by unrepresented litigants. The Canadian Forum on Civil Justice is developing resources, including an annotated bibliography, a manual for court administrators, and a bench book for judges. Subcommittees are exploring the adoption of a statement of principles for dealing with self represented litigants. The legal profession has also taken steps to address these challenges. The Canadian Bar Association Task Force on Systems of Civil Justice highlighted the need for improved public education, enhanced information and advice, and the creation of an optimal information and referral system. Additionally, Pro Bono Students Canada, established in 1996 by University of Toronto, matches law students with organization for pro bono work to represent people who cannot afford lawyers and paralegals. In conclusion, individuals representing themselves may face challenges due to a limited understanding of judicial system. The absence of legal assistance can make it difficult to navigate rules, deadlines, and formalities. Legal documents often involve intricate language, posing potential obstacles. Constructing robust legal arguments and engaging in legal research may be daunting for unrepresented parties. There is a pressing need to address the lack of comprehensive ethical guidelines for self-represented litigants, considering their increasing presence in the Canadian justice system. As the Canadian legal system grapples with these increasing prevalence of self-represented litigants, there is a shared vision for accessible legal systems that uphold the dignity and rights of every individual.